Now on to the courts, and the Office of the Attorney General and the Independent Electoral and Boundaries Commission have faulted both the High Court and the Court of Appeal for terming the Building Bridges initiative unconstitutional. Solicitor General Ken Ogeto, representing Attorney General Kihara Kariuki, and former Attorney General Githu Muigai, representing the IEBC, put on a spirited appeal before the 7-judge bench of the Supreme Court, chaired by Chief Justice Martha Koome. I don't know whether we have Seth Olale with us. Seth, what are some of the highlights of the arguments made so far?
Well, thank you so much and good afternoon, Olive Barros. The highlights we have, first of all, the former Attorney General, actually the former AG, that is Githu Muigai, rightfully stating that, you know what, him representing the IBC, faulting the lower court. So talking about the Court of Appeal as well as the High Court, which declared the BBI initiative unconstitutional. Because the former AG representing IBC stating that, you know what, IBC had quorum to perform its mandate, and so there will be consequences if the IBC is declared unconstitutional. Now, Solicitor General Kennedy Ogeto, representing the sitting Attorney General, that is Paul Kihara, stating that there is nowhere in this particular constitution that bars the power of the people from initiating a popular initiative to change the constitution. But let's just listen in on what those two had to say in regards to their submissions today before the 7-judge bench of the Supreme Court.
This solution is given effect in Chapter 16 of the 2010 Constitution. The procedure for amending the entrenched provisions, which is the basic structure, is elaborate and onerous. Our humble view is that judicial intervention ought to be limited to confirming that this consciously elaborate and onerous constitutional procedure is strictly observed and followed in amending the Constitution. The learned judges of the Court of Appeal erroneously elevated the basic structure doctrine to a universal template for certain constitutional amendments or change. This fails, my lords and ladies, to recognize that constitutions are not identical. In our humble submission, where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our Constitution, the basic structure doctrine has no place.
So earlier on, we had the judges of the Supreme Court turning away, or rather rejecting a request by a number of amicus in this particular case that wanted to be enjoined as supporting respondents. One of them is standing right beside me here, lawyer Dudley Ochiel. What do you have to say with the Supreme Court's decision?
Well, we weren't really trying to be joined because we're already part of the case, but we had wanted to enjoy the same rights, speaking rights, as other parties. But the court has said no, it won't listen to our oral arguments. It will just hear our case by paper. It will see what we've written and then make its decision. A decision which we still think is unfair, because we'd been treated as respondents at the Court of Appeal and we were given 30 minutes to speak, 1.5 hours in total for all of us who are trying to get just about 10 or 15 minutes in the Supreme Court. Well, it has made its decision and we live by it.
Okay. Remember that, Olive, it's just day one of the 3-day hearing of this particular BBI appeal case at the most Supreme Court in this particular country, being presided over by none other but the Chief Justice herself, Martha Koome. It's just day one. Today, what we know is we are going to hear more concerning the appellates, actually. We're talking about the IBC, the Attorney General, the BBI Secretarial, and of course, the President, being represented by a host of lawyers here. Tomorrow's, it will be the turn of the respondents in the case, of course, being led by the LSK chair, who's Nelson Harvey, representing the first up to the 5th respondents in this particular case. And of course, the D-Day for this will be the last day, which will be on Thursday, which will be the third and the final day of the hearings, and thereafter this particular court taking a break to go to retreat and of course now to announce its judgment. But we're camping here at the Supreme Court waiting for the afternoon session, which should start in less than 40 minutes time. Back to you, Olive.